This is the In Focus podcast from The Hindu.
Hello and welcome to another edition of the In Focus podcast. I'm your host G. Sampath. The Uttarakhand Assembly has passed the state's Uniform Civil Code. I did that last week and titled Uniform Civil Code of Uttarakhand 2024. This bill was one of the BJP's poll promises during the 2022 Assembly election campaign. And although this bill's applicability is supposed to be uniform, the law exempts tribal populations and also the Hindu Undivided Family from its purview. So, what's the legal history and background of this legislation? How does this law affect minority communities, considering that it's supposed to be uniformly applicable to all of them? And what's the controversy around its provisions concerning live in relationships? We take a close look at this bill in this episode of In Focus, and we have with us Professor Sarasu Esther Thomas from the National Law School of India, University, Bangalore. Professor Thomas, thank you so much for taking time out for us in the midst of your travels. Welcome to In Focus.
Thank you so much. I'm happy to be here.
Great. So, to start with, I was just wondering if you can give us a quick overview of the background and history of the UCC question in India. I was really keen on your comments on the fact that proponents of this bill like to say that the directive principles of the Constitution promotes a uniform civil code, whereas the Law Commission, for instance, has been less than convinced of how feasible it is, and there is a lot of back and forth on this question. So, what are your comments on this to begin with?
I think you've put those two things together quite well. One is, yes, under the directive principles of state policy in the Constitution, there is Article 44, which says that the state shall endeavor to bring about a uniform civil code. And the Law Commission has, in fact, said that we don't really need a uniform civil code. What we need is to bring in reforms in personal laws. So I think what the Law Commission was trying to say is that we do need to keep in mind constitutional principles of fundamental rights of equality. And, that is more important than bringing about a uniform civil code. But just to give you a background, the Uniform Civil Code debate, if you want to call it that, began with the Constituent Assembly debates. And while this article in this form was introduced by the Constituent Assembly, we had, people who had different views on whether the Uniform Civil Code should come into force immediately or not. One person I'd like to speak about is Dr. Ambedkar, who felt that, yes, a uniform civil code should happen, but he also felt very clearly that this should not be an imposition. And he said that, it's not that the state should enforce it on all citizens just because they are citizens. And he felt that the future parliament may make a provision by first saying that it will be binding only to those who make a declaration and then, take it forward like that. So in a sense, the way that the Constituent Assembly saw this directive principle, like many other directive principles, like on primary education, it took a long time. But the way that this directive principle, I think, has been seen by the Constituent Assembly is something that will be progressively realized, that it will be slowly realized over a period of time, incrementally and organically. It was never seen as something that would be an imposition. And I think this is clear from other parts of the Constitution. For instance, when you look at the seventh schedule, it has the union, the state, and concurrent list. And you will find that a lot of subjects that should be in a uniform civil code, like marriage and divorce and minors, adoption, succession, and so on, all of them are in the concurrent list where both the union and state can make laws. We also see that there are specific provisions. You have mentioned tribal laws. We also see that there are special provisions, for instance, for states in the Northeast, which protect their laws and their rights to make their own laws in this area. So the Constitution itself has a scheme for diversity. It does not see a uniform civil code coming in immediately. So that is what I want to say. The another point that I feel is really important is keeping in mind what Dr. Ambedkar said, that we already have a set of uniform laws. So, in a sense, we have already a number of smaller uniform civil codes. I can give you a number of examples. The Special Marriage Act is a uniform civil code which allows all kinds of marriages, including intercommunity marriages. The Protection of Women from Domestic Violence Act is a uniform civil code which protects women across all identities. The Adoption of Children under the Juvenile Justice Act is a uniform civil code which allows anyone to adopt a child. The Maintenance of Parents and Senior Citizens Act is a uniform civil code which specifically takes account of the needs of parents and senior citizens. So we have already a number of smaller uniform civil codes. We have been progressively realizing this right and incrementally and organically, bringing about change that better recognizes rights of certain vulnerable groups and families. I also wanted to say that, of course, this has been litigated in states and in courts, and courts have often said, either that you cannot test personal laws on the Constitution, or made broad statements saying that we need a uniform civil code. But as I said, this there has already been progress in a number of legislations, and I think that is what the Law Commission was also referring to.
Right. I mean, the two broad takeaways from what you have said so far, Dr. Thomas. One, of course, the Uniform Civil Code, right from the time of the Constituent Assembly debates, it was not meant to be imposed, but more of an incremental kind of a change, which is realized progressively over time, and we have already been doing that. And as you rightly pointed out, there are several individual smaller civil codes which are already in place, and people are welcome to take it up and make use of them on a voluntary or on a need based kind of a thing, rather than having it imposed or top down in the form of like an all encompassing legislation which we have here in Uttarakhand. And coming to this Uttarakhand bill, in a recent piece in a newspaper, Dr. Thomas, you have described it as neither uniform nor civil. So that's a very succinct way of putting forward a particular view of it. Can you please elaborate what you mean by this? And also, secondly, if it's a civil code, does a civil legislation by definition not have to, as in, is it required not, or is it expected not to criminalize violations of its provisions?
To your first question, definitely, as you also said in your introduction, it is not uniform as many groups are not covered. In fact, many areas are also not covered. There's nothing said about what happens to adoption or to custody or guardianship of children. And because the Hindu Undivided Family is also not covered, there is confusion about what happens. What are these rules that apply? Are daughters still co-partners in the state? So you can't have an area where no rules apply at all. So does the Hindu Succession Act apply to that? Does customary law apply? Uh, you know, uh, which school of the Mitakshara apply? So all this, there is still a lot of confusion, which is why I said it is not uniform. In a civil legislation, of course, you can have provisions which might criminalize violations. For instance, there may be a provision criminalizing child marriage in a child marriage. If a family law deals with child marriage, but this claims to be a family law legislation. It deals with family relationships, and it creates completely new crimes in areas which have never been criminalized or which have been decriminalized over a period of time. There are acts that are completely legal today which have been made illegal in this act, in this law. And this is something that is very difficult to understand. And we see this particularly in provisions dealing with live in relationships, which are not criminalized in the rest of the country, but here you find it being criminalized. So, my point is not that civil legislation should not criminalize violations of itself. My point is that this claims to be a family code and it suddenly criminalizes areas which have never been criminalized or which have been decriminalized over a period of time. So, in that sense, it's also creating a non uniform criminal law. The presumption is that criminal law is largely uniform. Well, it's not. But nevertheless, uh, this creates a non uniform criminal law as well by making certain things illegal.
Right. I mean, that's a very interesting way of putting it. I mean, not only is it a uniform civil code, is it it's a non-uniform criminal code, so to speak. I mean, it's difficult to wrap one's head around this aspect of this entire debate. Now, coming to the actual provisions of this legislation, I was just wondering. There's been a lot of discussion about Muslim personal law and Hindu personal law and so on. So, in this context, so what would be the impact of this bill on minorities on when it comes to marriage and divorce?
There would be a lot of impact on this code on both minorities and on Hindus, and I'll come to that. What would come immediately to people's minds might be the fact that monogamy is now the norm, and so of course it would impact groups that might be polygamous. There might also be the common knowledge that there would be loss of certain grounds of divorce. For instance, for formal divorce processes that are there in Muslim law, like khula that is used by the wife or talak that is used by the husband. But in addition to this, there would also be laws of Hindu customary divorces, which are protected under the Hindu Marriage Act, which will no longer be available under this law. And there are certain good provisions which are there in other legislations such as Parsi law or Christian law, which are completely not even considered here. So Christian law, for instance, was the statute that was most recently overhauled, and it has a more nuanced definition of cruelty, for instance, than exists in the older Hindu Marriage Act. And that could have been considered.
Like, can you
Um,
explain what is this more nuanced understanding of cruelty? Like, what is it? What do you mean by that?
all right. So, for instance, in Hindu law, the ground of divorce would just be cruelty. But Christian law requires something more. I'll just pull out the section and read it. So it says, has treated the petitioner with such cruelty as to cause a reasonable apprehension that it would be harmful or injurious for the petitioner to live with the respondent. So this is much more nuanced. So, it looks at actual harm. Unlike the Hindu law, which just says cruelty, and different judges read cruelty in different ways. So if a woman refuses to wear the Mangal Sutra, forgets to wear the Mangal Sutra, it might be cruelty. So it makes it very easy to, let a lot of personal opinions of judges, for instance, come into what is cruelty or not. So Christian law, when it was drafted, or rather when it was amended, gave a more nuanced view of cruelty to ensure that it would not divorce would not be just done very easily based on a whim or a very over broad definition of cruelty. So that's what I meant. But of course there are things that they could have taken from other statutes too, and we see that there is lack of clarity on marriage and divorce procedures. Section 5 of the present code that is proposed does not really talk about marriage ceremonies of Parsis or Christians. And Christian law has an elaborate procedure. You have to give notice of the marriage. You can't have an immediate, marriage, which is possible in Hindu law. This notice is called bans. Christian law is recorded in writing so that there is automatic record of the marriage. This has nothing to do with registration, but that's the normal way that marriages are done. So all these procedures are not really mentioned. So there is lack of clarity about how one actually goes about getting married under this code for some communities.
Right. So you're saying there is not enough clarity on how one gets married with all these provisions about marriage in this code being there.
Correct, correct. How different communities would get married is not really mentioned in this code.
But there is clarity on how Hindus can get married, right?
Well, what it says there is that marriage may be solemnized in accordance with the religious beliefs, practices, customary rites, and ceremonies. And it mentions Saptapadi, Ashirvad, Nikah, Holy Union. I'm not sure what Holy Union is, Anand Karaj, and so on. But it's a little it's not very clear because there are both in Christian law and Parsi law, there are clear ways in which you get married. Like in Christian law, that is automatically documented documentation of marriage, and that is not dealt with here. So when it says people may get married according to their practices or customary rites, these are not customs. These are created by other statutes that are not mentioned here. And it
So
says
if a Christian in Uttarakhand were to get married according to this Christian practice or whatever has been they have been following, that would not be recognized under this code.
I hope it will be recognized. But, lack of clarity does create difficulties for those who want to get married.
Right, right. Now, moving on to another important domain of this law, Dr. Thomas, which is to do with succession and inheritance. Can you please give us a quick sort of overview of what are the changes it brings in, which would be felt not only by the minorities but also by Hindus, the majorities, and so on?
Well, as you pointed out, this is a very important area which has not received much attention. So, if we examine the code, it has sort of cobbled together provisions of different laws, and they don't really gel together or sit together very well. So, they have put some of Hindu Succession Act, they've put some of the secular Indian Succession Act for wills, and sort of mixed it together to create a succession code. But the Hindu Succession Act has always been critiqued as a model that is not gender equitable. And I think this is also something that I had, mentioned in the article that you referred to. But Hindu law tends to give a lot of importance to agnatic relationships, that is, through a pure male line. And it looks at a woman as somebody who is part of her husband's family for the purposes of marriage. So to give you an example, um, in Hindu law, some of the relatives of the father get a better position than relatives of the mother. So for instance, uh, the stepmother, that is a father's mother, has a better right to the property than the woman's own, uh, you know, grandparents. So when you're looking at succession to a Hindu woman, it does not treat, or or even that of a Hindu man, it does not treat the relatives from the mother's side and the father's side the same. Now, this is not true of other laws. This is certainly not true of Parsi law and Christian law, which are both governed by the Indian Succession Act and which don't make a difference between your father's side of the family or your mother's side of the family. Both are very important. So they both also don't recognize certain relatives like, um, let me think of an example, like the stepmother or the step grandmother, or the um, brothers, you know
Right,
uh,
Dr. Thomas, you
widow, and
mentioned,
so on. Yeah.
yeah, you mentioned earlier that as you've explained, there is a serious issue of inequitable gender treatment in the Hindu personal law when with regard to succession and inheritance, and it's not the case with the Parsi and the Christian law, which are governed by the Indian Succession Act. But how does this work with the Muslim personal law? I mean, there are there gender inequities to be sort of dealt with through a uniform law?
Uh, yes, there are inequities there too. In Muslim law, the most common one that is usually mentioned is that the daughter gets half the property of a son. So definitely that would change, and daughters and sons would get equal rights. But in other personal laws, they already had equal rights, like Christian law and Parsi law. But Muslim law has certain interesting features as well. For instance, it could be argued that in Muslim law, there is something called a bequeathable third, that you can't will away more than one third of your property. So some of your property would definitely go to your heirs. Now, under the Indian Succession Act, testamentary provisions, which are now included in this code, you can make a will giving all your property to anyone you please. So you can effectively leave out, daughters from getting anything at all. So it's difficult to say which is better. Whether having a bequeathable third with a definite share of the property is better, or having a law that gives daughters equal shares in the property is better, or allowing a person to will away their complete property, leaving out, let us say, their wives or their daughters or someone else is all right. It is a compromise that is acceptable.
I mean,
But what I'm saying,
it has been pointed out, for instance, that allowing one person to will away his or her entire property could result in, say, widows or LGBTQ children to be sort of written out of their rights to whatever property. I mean, that's something which could be addressed by having this bequeathable, non-bequeathable two-thirds, so to speak.
sorry, I didn't get your question.
No, I meant that when you have a situation where you cannot bequeath your entire property to whoever you please, I mean that could sort of prevent misuse of this right by, say, writing out of your estate someone, say, a child whose sexual orientation you may not really like, or a widow, or whoever you may not agree with in your extended family. I mean, that kind of an eventuality might be sort of preempted by having, like, for instance, this bequeathable element being restricted to one third, is what I'm saying. The others would get their due in any course, in any way.
Yeah, you're absolutely right. I mean, that is why the bequeathable third is interesting. It's there only in Muslim law, it is not there in other laws. And that's why it's important to consider that, that fact completely, that wills, when they are made, are often used to disinherit and to perpetuate, patrilineal tendencies of property passing on from father to sons and so on.
Right. Now let's come to the aspect of this uniform civil code that has sort of attracted the most amount of attention in the media, which is to do with its provisions on live-in relationships. So, can you please explain what exactly does it mean when it says I mean, couples have to compulsorily register within 29 days or 30 days? So, where is this coming from? What happens if they don't register? How are live-in relationships defined? How is it different from marriage? Can you please take us through these elements of this code?
Well, live-in relationships is nothing like marriage. So let us see what the present law on live-in relationships is. It is not regulated at all. So, what is a live-in relationship? It could be as simple as, it would vary from the point that a couple is maybe dating or seeing each other, or they decide to stay together for some time. And when they start living together for some time, if they've lived for a long period of time, the wife has certain rights. For instance, the woman has certain rights. For instance, protection under the Domestic Violence Act, and so on. But here, what happens is that if a couple is living together and the state feels that they have lived together for a month or more and have not registered, that itself becomes a crime. So you can't just stay together and preserve privacy where that is concerned. If you do not inform the state and you do not register, you could be punished for up to 3 months of imprisonment. So, so that's what I was referring to earlier, that it suddenly becomes a crime.
Right. And the bill also provides for maintenance in case of desertion in a live-in relationship. Now, how is desertion understood in this context? I mean, suppose a couple is in a live-in relationship and one of them decides to move on. Would that be counted as desertion?
It depends on what kind of a relationship that person is leaving. Is the person leaving a relationship that has been registered, or is the person leaving a relationship that is not registered? Now, if a person is leaving a relationship that has not been registered, uh, then in this law, because it is protecting only registered relationships, it is not sure what kind of protection the woman will receive in this law. But certainly, under the domestic violence law, if there's been domestic violence, she would be protected because it recognizes live in relationships, whether it has been registered or not. But this law will protect only registered relationships from what it seems like it on the face of it. And there is of course an ambiguity where that is concerned. The focus of the law seems to be on getting relationships registered more than anything else.
Right. If a living couple has been living together for more than 30 days, and if the desertion, so to speak, quote unquote, desertion happens after, say, 45 days, wouldn't that anyway be counted as an unregistered live-in relationship, and therefore, I don't know, some kind of state intervention is mandated, one would presume, according to this code?
Well, this would be considered, since it's not registered, we are not sure whether the woman would have any rights under this code.
Okay. And if it's not registered, they would then both of them would have to go to jail, right?
Exactly. It would be criminalized. So it is unlikely that they would say that it's not registered, because it puts a burden on both of them to register it. But it does not really protect someone who has been there for 1 month. And generally speaking, even under the Domestic Violence Act, I'm not sure if a very short relationship for 1 month can be called would be a live-in relationship. It is too soon maybe for a relationship to be considered to be a live-in relationship at all. But you're absolutely right that there may not be any rights that the woman can claim, and if she does claim rights, it may lead to punishments for both of them.
Right. So, I mean, as you rightly pointed out, Professor Thomas, I mean, the main thrust of this provision seems to be to register this relationship rather than have a situation where you have certain rights for the woman emerging from that registration, so to speak. And this is interesting because, I mean, in media reports on this provision, Uttarakhand government officials have said that they decided to include this provision for compulsory registration of live-in couples in response to demands from elders in the state, from parents and so on, who are concerned about the abuse of women in such relationships, domestic violence and whatever other kinds of abuse. And it is meant to protect girls, because once such a relationship is registered, then there is a more fear, quote unquote, among the men, in terms of how they treat the woman in such a relationship, which is not so. Uh, it's not the same as an unregistered living relationship. Do you think this so-called justification of protecting girls or women in such relationships is a valid justification for having this kind of a provision?
I don't think the provisions on live-in relationships really protect women, and I don't know if that I mean, on what basis that justification is being made? Because if they wanted a law that would truly protect women, they would have better provisions within this code on domestic violence for married women, which we see absent. That's not really there. We would have a provision instead of criminalizing live in relationships, which criminalize marital rape, which is not really there. A a matrimonial remedy like restitution of conjugal rights, which can allow a husband to file for the and ask for a direction for the wife to come back and stay with him, which has been critiqued by women's groups everywhere as being absolutely violative of the rights of women. That is something that is still there in this code. So I'm not very convinced about this argument that all these provisions are made to benefit women when all these important areas which already affect women, which have been written about, which have been talked about, which have been documented, have not been addressed at all. And the fact that live-in couples, women and live-in couples face are the only people who face abuse is not right at all. All women face abuse, and I don't think that this uh, claim that this has come in for elders is something we must give much weightage from, because this has not come from the women who want to be protected. Elders, of course, want to control who their daughters and granddaughters marry, or who their granddaughters and daughters are with. But I do not think they have that kind of a right. It is for the women to protect themselves. I also am uncomfortable with the terms that have been used, which have been bandied about, that this is to protect girls. Girls are already protected. Minor girls are already protected under laws like POXO. But this law, live in relationships or consensual relationships or marriage are those that are chosen by adult women from the age of 18 onwards. They are not girls anymore, they are adults making a choice. And I don't think that elders can, um, force them to behave in a way that would restrict their rights. So these concerns of elders really seem to be to, you know, controlling the freedom and sexuality of young adult women. If the law was truly about protecting women, it would have removed restitution of conjugal rights, it would have criminalized marital rape, and it would have better provisions for domestic violence.
Right. Thank you, Professor Thomas. I mean, that really sort of exposes the real nature of this provision of compulsory registration. I mean, it's a clear litmus test. What you just mentioned, the provision of marital rape not being there and restitution of conjugal rights making it once again. I think these are clear litmus tests in terms of what the intent is, whether it is really to protect or is it to control the choices and sexuality of women. And moving on to another aspect of this debate, I mean, this bill, it sort of likens, even though it's not making it the same, it likens a live-in relationship to that of a marriage. So, what are the implications of this bill, if there are any implications for those live-in couples who are in a LGBTQI relationship?
All right. This code treats marriage and live in relationships very differently. As you've seen from how marriages take place, marriages don't need to be registered, they would still be a marriage. Marriages don't need any kind of formal procedure or even intimating the state that one is getting married. You can still follow your customary practices in getting married. Live in relationships, by their nature, are very informal. People may choose to live in, they may choose to, at some point of time, stop living in and moving on. Now, when you're looking at LGBTQI relationships, this entire law is set in a gender binary. It only talks about men and women. It does not mention anyone else at all. So, whether it's talking about a marriage or it is talking about a live in relationship, it is talking about men and women only. So now we have actually this odd situation that if a couple, a man and a woman, decide to either live together or have a legal relationship, that would be hit by the code. It would be criminal. But if you are looking at a couple that is a sexuality minority, an LGBTQIA plus couple, we see that this is not dealt with at all. So there is no question of a live-in relationship for them. There's no question of a marriage for them. So their freedom in living together in relationships is not really affected by this code. So actually, unlike other provisions of law, which are which protect couples who are in a gender binary of male female and do not protect LGBTQI community, this law actually criminalizes couples that are men and women in live-in relationships, but it does not deal with LGBTQIA. And this law, which has come soon upon the expression of rights of LGBTQIA, could have definitely addressed some of their these concerns, but it hasn't. If you look at the succession law provisions, that is also set clearly within the LGBTQIA framework. Unlike, let us say, the Indian Succession Act provisions, which don't talk about son or daughter, which say child. Here they do talk about son and daughter only. So when you're looking at succession law, it is still not clear how you would classify, let us say, a trans child. And it is not clear whether those who don't fall into a strict definition of a male son or a female daughter would be able to claim. It is also not clear if a trans person passes on, or somebody who um, identifies as gender non-binary passes on, how their property would go. Who would be their sons, who would be their daughters. It is not clear if any of their. It is definitely clear that their relationships that they have, their partners, would not be recognized under this law. So LGBTQIA relationships are not recognized in the succession law at all. And it is still set in a very male female binary. So difficulties that have been there in the older Hindu law continue to be here. And so this law is definitely discriminatory against this community.
Right. I mean, it's really ironic what you pointed out, that this LGBTQI aspect. I mean, where it's the heterosexual couples who are targeted through criminalization, but the LGBTQI couples are not targeted, and therefore, by basically leaving them alone or leaving them out of it, they don't face the same, not likely to face the same brunt of the law as heterosexual couples do, which is the reverse of what has been the case, or what has been the norm so far. And one last question, Professor Thomas, before we wrap up. So taking a big picture view of this bill, would it be accurate to describe it as an expansion in its essence of the Hindu personal law to other religious communities, bar the tribal population, or does it also need to be given credit for some genuinely progressive provisions, such as, for instance, eliminating polygamy and ensuring equal inheritance uh, for Muslim women, which are both pluses for them? How would you sort of give a big picture perspective on this?
Well, of course, the points that you mentioned regarding Muslim women, I think we have discussed in an earlier question. And certainly there are some good provisions, like it stand on illegitimacy. It has removed the notion of illegitimacy. So all children are legitimate. Uh, but your statement that it has expanded Hindu personal law to other religious communities is quite true. It has also, we are, expanded it to communities which may not be necessarily religious, like an atheist, for instance, would still be governed by this law. And we see that when we look at Hindu law earlier, it was actually a catch-all law. Its term or being called Hindu law is probably unfortunate. So it applied not just to Hindus, but it also applied to Buddhists, to Sikhs, to Jains. And it applied to anyone who was not a Muslim, a Christian, a Parsi, a Jew, or governed by tribal law. So this, expansion of Hindu law may not always be a good thing, because we have missed out good provisions from other laws. Like, I think the way that Parsi law protects widows is very good. Uh, the way that Christian law treats, relatives from both sides, agnates and cognates, equally is very good. And those good points which could have been taken from other personal laws have not been taken. So it seems to be an expansion of Hindu personal law, but without giving the benefits that Hindu personal law has, such as the Hindu Undivided Family, format, both as in family property as well as a business institution to other groups as well.
Right. Now, one final question before I let you go. This bill, I mean, there have been so many concerns which have been raised, which we discussed. I mean, assuming some sections or some communities or their representatives who are not happy with the provisions of this bill, they challenge it in court. Would it withstand, do you think, scrutiny in terms of its constitutionality? I mean, there are there are sort of many arguments being made that invades privacy, for instance, with its live-in relationship clauses, which is a violation of a fundamental right, and so on. So, do you think it's robust in terms of whether it's constitutional or not, or is it liable to be struck down as unconstitutional if it is to face such a challenge in going forward?
The provisions on live in relationships definitely are completely violative of the Constitution for many reasons. One is that it would fall within what the Menaka Gandhi, one of the judges, observed in the Menaka Gandhi case, that it's arbitrary, freakish, or bizarre, because it provides such a cumbersome procedure and such a criminalized procedure for an informal relationship, which it does not even for a formal relationship like marriage. So, certainly, the procedures and for a live in relationship are completely unconstitutional. It is also, as I said, violative of rights, of the freedom to marry, of uh, or the freedom of uh, you know being in a relationship of young adults, which has been protected by the law. Of course, when it's not consensual, then you have a provision like rape law. If it is underage, you have provisions like the POCSO, the Protection of Children from Sexual Offences Act. But where consenting adults are concerned, they have a right. And the Supreme Court has, in cases like the Navteej Singh Johar, upheld rights of consenting adults to be in relationship, even for the LGBTQIA plus community. So, this right has been impacted for adult men and women through provisions dealing with live-in relationship, and certainly it can be struck down. It is violative of couples' rights to equality, to privacy, to autonomy, to personal liberty, complete violations of Article 14, 21, etc. And so I feel that if it is challenged, it should be liable to be struck down.
Right. I mean, thank you so much, Professor Thomas. I mean, definitely on questions of, as you said, equality, privacy, autonomy, and personal liberty, there are a lot of problems with this legislation. And in the days to come, hopefully, there will be a greater scrutiny of it, and the right kind of actions will be taken. Thank you so much once again for sharing your observations and insights on this bill. Absolute pleasure talking to you. Thank you.
Thank you so much for this opportunity.
In Focus will be back soon with analysis of the biggest news issues. In the meantime, you can find our podcast on Spotify, Apple Podcasts, Stitcher, and other platforms. Just search for In Focus by The Hindu. We'll see you soon.